SJC-13561 and 13562, Commonwealth versus Dean F. Donald Jr. and Commonwealth versus Philip J. Marquis.
Okay, Attorney Rawl.
Good morning, Your Honors. May it please the Court, Assistant District Attorney Ryan Rawl for the Commonwealth on both these cases on behalf of Middlesex County. The motion judge clearly erred in allowing a motion to dismiss in both of these cases, where Massachusetts has the authority to implement a uniform licensing scheme to apply to all citizens, regardless of residency, under sections Chapter 140, Section 131, and 131F.
Which version of 131F applies to each defendant, just to clarify for me?
So there is a version of 131F that still has the language of the May issue scheme, and that, I believe, was only effective until August of 2022. And then Mr. Marquis has the newest version, which is current, until, of course, any revisions from the newest firearm legislation are applied to 131F. So there are two versions, one from 2021 till 2022, which still has the May issue language, and then Mr. Marquis' version of 131F, which no longer contains the May issue language.
And are you defending the May issue one after the Bruin case?
I'm not defending the language May issue, as I believe that that's not necessary in this appeal, and also I will point to the fact that the May issue language is actually not dispositive, as the Bruin court identified in the series of shall issuing licensing schemes. The fact that it says May issue is not itself dispositive on whether it is a May issue regime. So looking at 131F and
No, I'm sorry. You're saying it's irrelevant. That's it. That the statute for Mr. Donnell is May issue?
I would first say they don't have standing to challenge the language of the May issue, so I would say it's irrelevant for that purpose. But I would also say that the licensing scheme as applied at the time of Mr. Donnell's prosecution was more akin to a shall issue licensing scheme than the May issue that's described with the proper cause requirement as in Bruin. So it issued in effect as a shall issue regime, and that's clear also from the advisory opinion of the Attorney General.
Wait, I don't understand that argument at all. I have a chronology here, which I hope I have correct. Donnell is pulled over after his car accident in on November 8th, 2021. Bruin is decided June, and at that time, he's only charged with a misdemeanor, right? He's not charged with under Section 10A.
So he was originally charged with 10H and 10M, and then
Okay.
there was a decision made to keep the case in the district court, so the 10M was no process, and a replacement complaint was taken for 10A.
Okay, so 10A was not in the case when he's originally charged.
Correct.
Bruin's decided. Then the AG issues its advisory. And then Donnell's charged thereafter with 10A. So how is it that at that point we can say that the previous version of 131F should be construed as a shall versus may type of statute, when we have an AG advisory saying that's not the case and it's not being enforced?
I guess what I would say is that in being pressed that the May issue regime, as far as that language meant that it was a May issue regime, that would not be constitutional under Bruin. So that specific language and that aspect of the licensing scheme provision wouldn't be able to be enforced that way. But we don't have to reach that question.
So if it can't be enforced, then how can there be a charge under 10A at that point?
Because as this court acknowledged in the Kanjura opinion, and as numerous courts, as I referenced in my brief in New Jersey and California and also New York post-Bruin have applied, just because one provision of the statute is unconstitutional does not make the entirety of the enforcement of that scheme unconstitutional.
But that's not the test. You don't look at the whole scheme entirely. You look at 131F and see if that on its face is constitutional, and that has, for Mr. Donnell, a May issue provision.
So every court that's addressed this question of the May issue licensing language existing, and in fact, for the other matter, the proper cause, which is even more problematic and is expressly unconstitutional under Bruin, has analyzed this all the same, which is they look at the person's underlying conduct, and like in the California and New Jersey cases that I cited in my brief and subsequent New York cases, when someone chooses not to get a license at all, those provisions are in fact severable from their ongoing prosecution. They had no effect on their prosecution, and the court has routinely upheld the licensing scheme as it is enforceable to be constitutional.
Is that the same thing as anybody who's convicted under 10A pre-Bruin, under the May issue statutes don't have the benefit of Bruin?
Correct. Well, yes, except insofar as...
Because they can't say that, and I forget the name of our cases that hold it, they can't say that I would have gotten a license, but they never applied for one.
Correct, and actually the best analysis for that is what happened post-Bruin in New York. It's not that every single conviction that was previously obtained in New York prior to Bruin was invalidated immediately. And I think that starting in the historical narrative here, it's clear that 131F is facially constitutional under the Second Amendment. Looking to the same historical analogs provided in Bruin and reasserted in Rahimi, we have the surety laws, we have the going armed laws, as they're called, or the brandishing arms. We also have...
Don't all those statutes involve threats?
Those involve risks to public safety as...
But by dangerous folk.
Right, and besides those, we also have loyalty oath statutes that existed, as well as historical events.
I guess you put you in that strange position of arguing like the anti-Catholic cases support you.
So I'll start by saying I don't think you need to get there, because I believe that the loyalty oath cases set a prerequisite that you have to swear after the American Revolution. You have to swear loyalty to the United States and/or your specific colony before you're allowed to be armed. And we have the example of the Shaw's Rebellion in 1787, which makes it clear that people who pose a public safety risk because of their allegiance to an enemy we just fought is a prerequisite to disarm them entirely.
But don't we have to look at statutes that involve regulation of people who otherwise would have a legitimate right to carry a firearm?
Right, so when we establish this uniform licensing scheme, I think the best way to look at it is the way that Rahimi itself said it, which is we look to whether the why is analogous and we look to whether the how is analogous. And I think that the why is analogous here clearly as in Rahimi. I think Bruin made that clear in footnote 9 when it said there was no question as to the constitutionality of shall issue licensing schemes generally, that just checked to see if, in fact, people were law-abiding, responsible citizens. And when I say responsible, I'll adopt the general solicitor's argument in Rahimi, which is either pose a risk of harm or danger to others, or due to the characteristics pose an increased risk of danger.
Well, what do we have here, though, to have these two cases be informed by Rahimi? Because there's a significance to the fact that there was a hearing where Rahimi had an opportunity to contest the allegations, and the court made a finding that he was dangerous. There was lots of evidence that Mr. Rahimi was a danger to the public. It wasn't even just the index domestic violence charge. Here, what do we have here to say that that's all instructive in our analysis?
So what we have here is a state licensing scheme that allows the executive authorities, the state, in this case, the Massachusetts State Police and the Firearms Record Bureau, to identify if people are, in fact, pose a risk of harm or public safety first. That's a judicially reviewable decision that is allowed to be appealed. And so, like Rahimi, what we have here is a scheme that's designed the exact same way, which is to ensure that people who pose a threat or public safety to the community are not allowed to be armed. We have a judicial reviewable decision if they in fact apply for a license. And of course, this is all presupposing that they have standing to raise these various provisions, which I won't belabor because we're all here, but the point is they do not, and the motion judge erred in that regards as well. But putting that aside...
they have standing to raise a facial challenge, right?
They do.
Okay.
But a facial challenge as to sort of the provisions that are relevant to their conduct. And what's relevant to their conduct...
They have standing to challenge the constitutionality of Section 10A, both as applied to them and on its face.
I disagree with that. I believe that
why? They're being prosecuted under 10A. How can they not have standing to challenge its application to them?
This court has repeatedly said in Powell, Loldhalt, and also circuit cases have said in a challenge in a criminal conviction, when one chooses to violate the law and not proceed with the licensing scheme, that they are limited to a facial challenge, both of the licensing scheme but also 10A. But even if the court does choose to do an as-applied challenge in this case, we have two different defendants, one of which was recently convicted of drunk driving. So I can say this is not just an allegation, he was driving drunk, through Massachusetts for however long, and the other individual works in Massachusetts and was traveling to work in Massachusetts carrying an unlawful firearm without being licensed. So when you apply the conduct, what is it that they're being prosecuted for? Making no attempts to get a license whatsoever. It isn't about the may issue language of the regime. It isn't about the incorrect interpretation of 131F by the motion judge and the defendants that it somehow restricts non-resident licenses, which it does not.
They're not really being prosecuted for not trying to get a license. I mean, they're being prosecuted for carrying a firearm or possessing a firearm without having gotten a license. I see a distinction between those two things.
I guess what I would say is they're being prosecuted using the plain language as not having in effect a license. So to challenge that requirement, they have to prove that under no circumstances can a non-resident be required to have in effect a non-resident license. So
Do you lose if we disagree with your proposition that the statute only applies to non-residents who are traveling to this Commonwealth for shooting competitions?
I strongly dispute that description of that. I think that the
Okay,
amicus
like the question I have is, do you lose on the interstate travel part of this?
So I don't think I lose on it. First of all, I'd say that I think the only interpretation is as the amicus brief does. And in fact, for this court to agree with the motion judge, it would turn on its head how we analyze statutes. It would find the statute to be unconstitutionally interpreted in order to get to the result that the defendants have standing. And
humor me.
okay, sorry.
We disagree with you. Do you still lose?
No, and the reason we don't lose is because even if the provision as it existed, that restriction, they still don't have standing. So we still have the standing problem here, which
But
is,
they have the standing to bring the facial challenge.
Right, and this
And
is,
if the statute only allowed, and I'm not saying I agree with this, but if the statute only allowed a non-resident to get a license, not for self-defense, but only for these competitions, that seems to squarely violate Bruin.
I agree that the restriction would violate Bruin. I think
So
the
that
issue,
means it violates the Second Amendment, which means you lose.
where I disagree that I lose is where we get wrapped into the standing issue, which is that making no attempt to get a license whatsoever, and their reliance
Why would they
on-
get a license if the provision only allows them to get a license for competition, and they don't need it for competition? They need it for self-defense. There's no provision for them.
So had they applied for a license and someone tried to restrict their ability to sport in competition, they would have a right to appeal that determination, fight that. They would have various options available to them, pre-enforcement federal challenges to the statute if it was actually interpreted that way. I do think it's somewhat of a legal fiction because there's no record of anyone ever receiving this type of restrictive non-resident license. There's no evidence of a previous prosecution for this. In the Simkin case, which this court has
We're on a
addressed-
motion to dismiss, right?
Correct.
Okay.
And so there's no area in the record or evidence to support that interpretation besides the fact.
In one of the amicus briefs, there was I think a breakdown of some 5,000 people who have non-resident licenses. Are you aware of this?
I did see that there was a reference to a number of people with non-resident licenses.
Have you looked into this at all?
So I spoke very briefly, and I'm happy to submit something to the court in a 16L letter with more definitive statistics.
That's what I'd like to know is how many LTCs are there for residents and how many LTCs are there, or temporary LTCs there are for non-residents, and did that change when the statute changed?
My understanding is that the numbers have been jumping up exponentially over the last few years since, let's say, Bruin itself. So I don't know.
I'd like to know the pre-Bruin number and the post-Bruin number of non-resident temporary licenses.
Maybe you can submit a 16L.
I can certainly try to seek that information from the Firearm Record Bureau, who keeps track of the non-resident in particular, and compare that.
You had begun earlier before I probably cut you off. Sorry about that. To discuss the why and the how historic analogs. Can I ask you to address the how portion in light of the 18-month mandatory minimum for violation?
So as to the how, I don't think that the 18-month mandatory minimum plays into that. And the reason I say that is also why I address that it doesn't constitute cruel and unusual punishment when that's sort of wrapped into a Second Amendment argument by defendant Donald's attorney. But what I'll say briefly on that is that the how, Rahimi had to do with a prohibition for him to have a firearm at all and be subject to a very high maximum sentence. My memory of the federal statute is that it's a 10-year sentence. And while I understand that that's not a mandatory minimum in the normal sense, federal sentencing guidelines make it more akin to a mandatory minimum as a general principle than, say, Massachusetts law, which doesn't have codified sentencing guidelines. So I think that Rahimi, the how is basically the same. That the how is that these laws allow the government to create these types of prophylactic measures to ensure that the dangerous or certain classes of people, such as the mentally ill, which pose an increased risk
But
of
is that
danger.
the right analog? Because, I mean, it's the out-of-state licensing scheme that is really the most appropriate analog, isn't it? But bear with me for a second, because, I mean, they're going to get up and talk about sort of the highwaymen and the dangers of travel. Isn't the analog not sort of generalized, but what is the rule for out-of-state, in this case, license holders? They have a license from out-of-state, and what kind of rules can we impose, and what kind of rules are the historic analogs to those? Isn't that the better analog rather than the general one about, mentally ill or convicted felons?
So I have a few responses to that. Let me start by saying that I think that the traveler's exemption, as is sort of outlined in the NRA amicus brief in particular, I think it makes too much of that exemption to be applicable to non-residents generally. I think the Massachusetts Attorney General amicus brief does an excellent job of describing how the history of this has to do nothing with whether you were a resident or non-resident at all. That being said, the analysis, as the Commonwealth sees it.
Well, that can't be true, though, because the statutes draw distinctions between residents and non-residents and aliens. There's a 1957 statute, there's a 70-something statute. So this idea of the different classes was on people's minds, wasn't it?
Well, the modern statutes do, but that's what's sort of interesting about the historical analogs and history of this country, which is why the Commonwealth focuses heavily on pointing out that Massachusetts, as all colonies and states, whether we're talking about the founding era or moving forward into the passage of the 14th Amendment, have this foremost prerogative and sovereignty to create their own criminal code and enforce it as a general principle against all who go within its borders. And that is, I think, the correct historical analysis here. As the Hamilton and Palazzi case said, we live in a nation.
I get the general federalism principles. I'm more focused on the analog, and also one thing you jumped to, that it's a rational basis. So we don't have a uniform standard. We apply different standards to non-residents and aliens than we do to residents. It's not totally different, but it is different. Do we subject that to strict scrutiny, or do we subject that to rational basis? Because I think the U.S. Supreme Court's saying the right to carry a gun is a fundamental right. Is that right? Are they saying that?
They are saying that, but it still gets you to rational basis, and here's why. First, non-residents are not a suspect class, so we take that out. I know that.
But if fundamental rights and equal protection, there are two ways to strict scrutiny. Fundamental rights generate strict scrutiny, and equal protection violations generate strict scrutiny, right?
Correct. And so when you're asking the question, it's not whether any regulation on a fundamental right is not allowed on a non-resident, and it's not even that there can't be differences between non-residents and residents in how it's applied in the law. What it requires is that it be substantially burdened, that it burdens a fundamental right. And the Commonwealth would argue that the distinctions that the motion judge relied upon and the amicus and the defendants point to, such as waiting periods or the length of a license, these don't rise to the level of burdening the fundamental right. Even if they did, and I argued rational basis is applicable here, but even if it did, I think that the Bach case and the
I'm
Raleigh-
confused by that. So if I'm licensed in New Hampshire, I have a license to a gun, and I work in Massachusetts, and I can't use that gun for a fairly significant period of time because we don't do them quickly. That doesn't burden the right? I just want to make sure I understand your argument on that.
My argument is that all of the requirements, even the differences between non-residents and residents, are constitutionally permissible under the Second Amendment. I do acknowledge that there are some distinctions. These defendants don't have standing to raise them, but there are some distinctions between non-resident and resident. But why they are satisfying a compelling interest and they satisfy strict scrutiny is the compelling interest is the one that is fundamental to the entire licensing scheme. It's designed to...
I think you may be right, but you are applying strict scrutiny there. You're not applying a rational basis if you're saying there's a compelling interest in support of that regulation and it's the least restrictive, which I don't know if it is, but that's the harder part.
Right. So I do think rational basis is the appropriate test. And I say that because the difference in the length of time, for example, is not a burden on the fundamental right to
Has the
bear
U.S. Supreme Court said it's a rational basis that where they said it's a compelling interest, and I don't know what Bruin says on this.
So I think the fundamental principle, both in Massachusetts and federal law, is that when we get past the equal protection issue, which I don't think is an issue here, it's whether it's burdening a fundamental right. So the first question is whether the difference in the length of time is burdening the fundamental right to keep and bear arms, for example. And I would argue...
Could you analyze that for us then? So this man, he doesn't apply for a license. I get your argument that he loses no matter what. But if he can challenge the statute on its face and there's no way he could have gotten the license, what's the time? There's no time frame for getting a license, right?
There's no time frame for sort of a waiting period, correct. There's a time period to process the application that is slightly different for non-residents than residents.
What is the difference?
My memory is that the maximum waiting period for the processing of the application for non-residents is 6 months, and the maximum for residents is 90 days. It's actually shorter than 90 days. I believe it's 60 days, but once it hits 90 days, they have an automatic right of appeal for a timeliness issue that gives them sort of a presumption that the license is issued. And so
non-residents wait up to 3 times as long to get a temporary 1-year license as residents who get a 5 to 6 year license. Is that right?
I wouldn't say, and there's no evidence or record as to how long these actually take, so I don't want to say that I said the maximum period that is allowed under the statute. And I think the reason for that is very clear in the Bach and Culp cases, which is that the state has an interest in monitoring and collecting information. If it is a Massachusetts resident, they have access to all of the authorities that law enforcement have in Massachusetts. They have access to all these police reports, CAD reports, other incident reports, and they're able to make a quick determination as to whether or not the person is a law-abiding, responsible citizen. There's no requirements, for example, and I note this in my reply brief, for New Hampshire to tell even the federal government in terms of background check about disqualifying.
I get why we want more strict requirements, and I get that we can impose more strict requirements, but I'm wondering whether I get you may be right that it satisfies a rational basis, but that means this person has no right to come into Massachusetts with a gun, or even though they're working in Massachusetts for as long as 6 months, maybe even longer.
You have another problem too, to Justice Kafker's point, right? Because you're waiting, and they have a right for self-defense, and if they come in, they're looking at an 18-month man-min, right?
Right, but insofar as that is a problem, it is also a problem for a normal resident who needs to wait until the background check and processes are done before they start carrying a firearm within Massachusetts. And I think that
But it's a much shorter time frame. So if you look at both sides of, if you're saying the strict scrutiny and you're saying the least restrictive, right? The least restrictive is the 18-month hit?
right, so I don't want to intermix the potential penalty with the analysis under the burden for the constitutional right to travel, because I think that it is, first of all, the same for residents and
Why,
non-residents.
okay, but why isn't the penalty, even if it's the same, part of the burden?
So I think that the question of the burden stems from what the regulation is requiring, not non-compliance with the regulation under a subsequent statute. So I think that the question about whether 131F's longer period of time it takes to sort of finish the background check process is an interesting one. I think it's one that if these defendants were in fact waiting, there may be a decent argument here about that. But in terms of how 10A is applied and the penalty portion is applied, that's not the burden we're talking about when we're talking about this regulation, because it's a choice of noncompliance.
May I ask a question that builds on Justice Kafker's question? And I'm trying to probe what the outer limits of your argument are. If you have a New Hampshire resident who lawfully possesses a firearm and has, let's just assume for this hypothetical, has a New Hampshire license. As my understanding is, New Hampshire is a voluntary licensing jurisdiction, so they can get a license. So let's just assume he has a license. And that New Hampshire resident wants to drive from New Hampshire to Connecticut, passing through Massachusetts. And the New Hampshire resident complies with the federal rule of unloading the gun and keeping it in a locked container while he's in transit. I take it, if I understand your argument correctly, that from the moment that resident crosses the border into Massachusetts until the moment he crosses out into Connecticut, he is violating, he could be charged under 10A.
No.
Why not?
And this actually speaks to the point of why non-residents, I mean, not that we're required to give them greater privilege, but in fact, they have greater privileges than residents. 18 U.S.C. 926A, which is the carrying through statute, there's a state exemption for that, but it's also the federal exemption applies. And so if you can show that you are statutorily exempt from following the license laws under 10A, you can't be prosecuted for it. So you can and not, in fact, be prosecuted if it's being faithfully applied the way it's supposed to be. And there are various other exemptions that are given to non-residents.
Where is the exemption? Where is that exemption?
So 18 U.S.C. 926A is the exemption for the federal. And
Are you saying that in the in-transit circumstance, the person is exempt from having to obtain a 131F license?
Correct.
Under state law?
Correct.
Okay, but if he's coming in, and it's not just in transit, it is, for example, well, we don't know in the case of Donald whether he was in transit or not, correct?
Well, all we know is that he was driving drunk in Massachusetts.
Okay, but we don't know whether he was in transit.
Correct.
Okay, so he may have been entitled to that exemption.
If at trial, if he can show that he was traveling from New Hampshire to another state where he was lawfully allowed to carry, and it was, my memory is that they were not properly secured under what would be the state exemption, but he may qualify for the federal exemption.
So,
Loaded as well, right? So
Right.
it doesn't matter.
Yeah.
So my memory was that it was,
That Donald was loaded, that's why I charged him under 10M.
10M was a large capacity magazine found
Okay.
next to. I don't actually believe it was loaded. There was ammunition in the large capacity, which we
I thought
chose
there
not
was
to
one
pursue.
bullet. There wasn't one bullet?
There was
Yeah.
one bullet.
There was one bullet, right? In the gun.
I misspoke, I apologize, but either way, he wouldn't be qualified for the exemption if it was
so Marquis, in your view, Marquis doesn't qualify for the exemption because he was coming to work rather than simply passing through.
correct. He was not going from one state to another. He was not using it for one of the many exemptions that non-residents have, such as for hunting or shooting range or a pistol competition or a shooting competition. So he was required to get a non-resident license if he chose to carry it for all purposes while he goes back and forth to work in Massachusetts. And that's just consistent with what residents in Massachusetts have to do. I know I'm well over time, but I would be remiss if I didn't at least make some comment briefly on the request from Defendant Donald to add an element to 10A of essentially knowledge that it's illegal to, I think that my brief addressed this sufficiently, but I just want to say that even the logical extension of that argument would be that the defendant needed to know that he didn't have a non-resident license, not that he didn't know that it was illegal or that he was not in compliance. I just want to leave it at that and say that because I don't know that that was clear from my reply brief. But if there's no other questions, I'll yield the rest of my time, which I don't have, to my brief.
Thank you. Okay, Attorney Levin.
Good morning. May it please the court, Patrick Levin on behalf of Dean Donnell. I hope to discuss the issues that I've raised in the brief regarding Section 10A, as well as the Second Amendment issues relating to the unconstitutional may issue scheme that previously existed in the Commonwealth. Attorney Barnwell will address the broader Second Amendment questions and the right to travel. Before I get to that hard stuff, I just want to emphasize that the affirmance in Mr. Donnell's case must, the dismissal in Mr. Donnell's case must be affirmed because this complaint does not allege a crime. He cannot be prosecuted on a complaint that doesn't allege that he was not licensed to carry. So moving to the issues that I've raised with respect to Section 10A, there are two provisions of the statute that I take issue with, and they're intertwined. So the fact that the statute does not require any awareness of wrongful conduct is a huge problem in light of the stiff mandatory minimum sentence. Or alternatively, you can view it the other way, that the mandatory minimum sentence is a huge problem, especially in light of the fact that no knowledge of wrongful conduct is required under the statute.
Can I just, sorry, you had made an initial point, and I'm just looking at the complaint. It says that Donald had the firearm not having in effect a license to carry firearms. Why isn't that enough?
Your Honor, I apologize. I don't have the complaint right in front of me, but
I do. But I thought your position was they didn't allege that he didn't have a license, but it sounds like they did.
So, Your Honor, I don't agree. And so the complaint, so there's two complaints against Mr. Donnell. They're both in the record. But the complaint at issue here, all it does is add the 10A charge. But the application for the complaint does not say that Mr. Donnell did not have a license to carry. It doesn't suggest any investigation into that. And in fact, to the extent that the application did contain any allegation, it alleged that he did have a license because the initial complaint charged him with carrying a firearm while licensed and intoxicated. So moving back to the constitutional...
There was no motion for a bill of particulars?
No, Your Honor, there was a motion to dismiss for absence of probable cause, which that's what we're here on appeal of. So coming back to this question of whether the statute now, in the wake of Bruin and Guardado, should be construed to require knowledge as to all of the elements that follow the knowingly phrase in Section 10A. This is a classic principle of statutory interpretation that we presume that a statute that says, you're in violation if you knowingly and then enumerates the elements applies that mens rea to all of the following elements. And the fact that this court has now recognized that the noncompliance with regulatory requirements is an element of the crime also requires you to apply that knowingly mens rea to that element, because that element is the only thing that distinguishes constitutionally protected conduct from a felony. I think if you synthesize this court's decisions in Jackson and Kelly and Guardado with the U.S. Supreme Court's decisions in Lambert versus California and the statutory construction cases following Morissette, and especially Staples versus United States, you cannot come to another conclusion. That in Jackson, this court concluded that Section 10A was not intended to be a public welfare offense, that it was intended to incorporate some mens rea, and they rely on the Lambert decision, and that's in part a constitutional avoidance holding. But in so holding, they confront the very argument that I'm making here, that awareness of the requirement of licensure was also required. And they say, no, that's not necessary to distinguish a guilty mind from an innocent mind because, and they rely solely on a United States Supreme Court decision that says, you know that possessing hand grenades is not an innocent act. Well, in Staples, the US Supreme Court makes clear that that's an error, that knowing that you possess a hand grenade is very different than knowing you possess a gun. And in fact, if you look at Heller and compare Heller with Staples, the line that they're drawing in Staples in some ways is the same line that Heller draws in terms of what is an arm that's protected by the Second Amendment and what is a dangerous and unusual weapon, or a weapon that's not in common use for a lawful purpose. What Staples says is if all you know is I have a gun in the ordinary meaning of the word, an instrument that is commonly possessed for lawful purposes, that's not a guilty mind. And we shouldn't.
I'm just trying to make sure I understand your argument. Are you saying that you need to know you need to be licensed, or do you need to know that you need to get a second license?
That you need to know you're not allowed to have the gun in Massachusetts as applied to this case. So there should be a showing, and this is hardly an impossible showing to make. Any evidence of consciousness of guilt, of concealment of the gun from authorities certainly would suffice.
What about the fact that there's something in the record that New Hampshire says that your license only applies in New Hampshire? Is that enough? That you,
yes, if there was evidence of that at trial, certainly. But there's no allegation of that in this complaint. And that's the point, is that the complaint doesn't set forth probable cause that Mr. Donnell did not have a wholly innocent mental state.
So if I understand what you're arguing, mens rea would require not simply the mens rea of facts, but mens rea of the law?
So what it requires is knowledge as to the element that provides the distinction between innocent conduct and wrongful conduct. And when the Supreme Court confronts...
Which in this case would be that he had to get a license.
Right. And so when you look at cases like Lambert versus California, and then Liparata versus United States, and Rahaif versus United States, and Ruan versus United States, these are all cases where that key element is a lawful or a regulatory element. And the Supreme Court doesn't hesitate to construe federal statutes to require knowledge of that regulatory element, or in the case of Lambert, which is the only one of those cases that involves a state statute, to say that the Due Process Clause requires such knowledge to be imputed.
Did New Hampshire ever require licenses?
Yes.
And when did that end?
I believe it was 2017 or 18, but I wouldn't want to.
And what is the, as I understand, there are voluntary licensing regime now. What are the benefits to getting a license? Why would a person get a license?
So I think the likeliest reason would be that many states, although not Massachusetts, do have reciprocity agreements. And so if you are licensed in New Hampshire and you travel to a state where there is reciprocity, then you don't need a license from the.
Does your argument in writ large mandate reciprocity?
I think. Well, I think that the answer is yes, provided that the home state has, some, like, I think there could be some minimum, like a statute that provides for some minimum level of screening in the home state. And then you could say, okay,
Well, what if the home state's a constitutional carry state?
so in that case, the reciprocity question is not quite the same, right? It's not reciprocity, it's nullification
All right,
almost, right?
So to take an easy example, non-controversial, assault rifles, all right? In the 2A advocates would say there's no such thing as an assault rifle. That's a made-up term.
Right.
Some other states, like this one, says it's absolutely a term. It's very controversial in the 2A world. If someone in a constitutional carry state were to comply with the Second Amendment, you have an absolute right to carry what we call, in this state, an assault rifle. Can that person, under your scheme, drive into Massachusetts, visit Massachusetts with an assault rifle in the back seat?
So, Your Honor, I suppose that my real answer to that is I don't need to go that far because Mr. Donnell is.
You know I'm going to press you for an answer.
Well, so Your Honor, if you're going to force me.
Because this would lead to that hypothetical, because we're talking about essentially Bruin allowed for exchanged Heller and McDonald to say the right to carry is no longer in the house, it's the right to carry outside the house. Now, as I read this is the right to carry outside the house and into another state. So, again, getting back to the hypothetical, would the exercise of the right, the Second Amendment right in a constitutional carry state, allow someone to enter this state with an assault weapon?
So, Your Honor, I think that the answer to that question actually depends on the answer to the assault weapon question. If that's an arm or not under the Second Amendment. And
Well, all right,
and
so the constitutional carry state would say absolutely.
Right,
And this state says no.
And so I'm not arguing that Massachusetts is required to defer to the law of other states on all questions. And so if you accept as correct, for example, the recent Fourth Circuit en banc decision that says assault weapons don't fall within the Second Amendment's protection, then obviously Massachusetts is free to criminalize those weapons. And so it's a separate question than the right to travel question.
And
You see
the
what I'm
reason
saying?
I didn't raise the extended magazine or the high capacity magazine, because that's part of 131F, right?
Well, that's true, but also he's not charged with that anymore.
Right, I know that, but I'm just thinking about these hypotheticals about how far this forced reciprocity goes
Right.
to this state.
Well, and if I may, Your Honor, if you'll forgive me and allow me to defer some of these questions to Attorney Barnwell and fall back on, because Mr. Donnell is being
I
prosecuted.
look forward to asking Attorney Barnwell these questions.
Because the thing is that my case is much easier than that. Mr. Donnell is being prosecuted under a statutory regime that even the Commonwealth concedes is not constitutional. This may issue regime.
And where does this take us as far as Guardado on steroids, essentially, if we say that the may versus shall licensing scheme makes it constitutionally infirm for these people? Does that lead us to our case law about you didn't have a license, you don't get to play, essentially? Does that hold true for all the Guardado folks as well as your client? Anyone that was convicted under 10A?
I'm not sure I'm following your question.
Right,
Is it a retroactivity question or is it a standing question?
So right now, the law is that you can't say, I would have gotten a license.
Right.
That's not a defense to a 10A violation.
Right, okay.
Right? If we agree with you, does that law go away?
So as to people charged,
Post-Bruin, I guess.
as to people charged under the unconstitutional may issue statute, the answer is, in effect, yes, although not quite in that way. That the point is that if there is no facially constitutional means of obtaining a license, then what you have in 10A is just a ban on carrying guns, effectively.
So we basically take the Holden and Guardado and we say post-Bruin, all the 10A violations, even for residents as well, are invalid.
Yes, as to
Because
people,
we had the may issue statute.
right, as to people charged under the may issue regime. That's correct.
That's a result of what you want us to rule in this case.
In effect, yes, although this case, by its terms, only presents the application of Section 10A3 and Section 131F.
Right, this only applies to non-resident, right?
Right.
But the result of that ruling would be residents would get the benefit of the elimination of the licensing requirement.
Yes, I believe so, although I do note in the brief that Section 131F is actually in some ways a doubly problematic may issue statute. It entails more discretion on the part of the state police colonel than even the Section 131 little d does to the licensing authorities for Massachusetts residents. And so it's, I mean, even if you were to uphold the, to somehow sever and uphold pieces of Section 131, but I will, to the extent that what you're trying to do is save some of these prosecutions, I also would say that
I'm dealing with the consequences, as you well know, from Guardado.
right,
And now we don't have a new trial, we have a prohibition as well, right?
well, so what I was going to say is that potentially, in terms of which parts of these statutes it's possible to save, the prohibited person section is not challenged in this case, and frankly, it tracks pretty closely with the prohibitions in federal law of under Section 922G of people who are not allowed to carry guns at all anywhere in the country. And that's Judge Coffey's point below to a certain extent, is that we have the Massachusetts prohibited persons and the federal prohibited persons are basically the same. And if you're a prohibited person federally, you're also not lawfully allowed to carry in New Hampshire. So, as to anyone who's lawfully allowed to carry a gun in New Hampshire, we already, if you're allowed to carry a gun in New Hampshire, then that means you're not a prohibited person in Massachusetts either. And the only basis to have denied a license would have been the unconstitutional discretionary bases. Do you see what I mean?
I do.
And so, in terms of severing pieces of the statute and striking them down, even if you say the only parts of the statute that were unconstitutional were the discretionary may issue parts of the statute, okay, so perhaps it would have been constitutional even under that statute as severed to prosecute someone who was a prohibited person. Do you see what I mean? Mm-hmm. But of course, in this case, we have 2 New Hampshire residents who were lawfully permitted to carry in New Hampshire, and so it was only under the unconstitutional may issue provisions that they could have ever been denied a non-resident license.
When you say lawfully permitted, you mean lawfully allowed as opposed to having a permit in New Hampshire?
Right. There's no evidence in this case that either of these defendants had the optional permit. It's just that they were lawfully allowed to carry because they were not prohibited by federal or New Hampshire law. And so just to circle back. Oh, no.
Wait,
Okay.
yeah, I'm sorry. So we're 10 minutes over, and I just want to make sure that whatever it is you were going to say, it sounds like it might be something you said already.
It was I was just going to ask if anyone had any questions
Oh,
about
good. That was what I was going to ask as well.
about the
Does anyone
standing
have any other
in particular.
Okay.
Okay.
Thank you so
very
much. Okay, Attorney Barnwell.
Good morning, Your Honors. I'm Hayne Barnwell on behalf of Philip Marquis. So there have been a lot of issues touched on in this case. I would just like to zoom out a bit and just state that whether it's in their brief or today, the Commonwealth has not shown a relevantly similar historical analog to this law. Rahimi also, I mean, beyond Bruin, Rahimi also dooms its argument because Rahimi makes clear how narrow the holding is. We are only today saying that if a court, and specifically a court, finds that this person is dangerous, that the state can regulate or even, ban that person from having a firearm. But it also cautioned, after that narrow holding, that the broader you go, the broader the prohibition is, the more constitutional peril the state will be in.
But counsel, how about the circumstance that you're pointing out, though? I get you with Rahimi, that's not necessarily instructive here. But getting aside from the optional licensing that you might do if you're a New Hampshire resident, if you're going the route of the constitutional carry, why is it that there isn't, even under a rational basis, a reason for this Commonwealth to say there's been no vetting of the New Hampshire resident? So even if you have this right that Bruin has again reaffirmed, that Massachusetts shouldn't just be allowed or forced to just say, "Olay."
Because, that gets to reciprocity. My answer is that Massachusetts does not have to have a reciprocal regime or recognize a New Hampshire license, for example, or authorization. It's just that Massachusetts can't be less protective than the Second Amendment, and that's the problem.
Well, I guess it depends on whose Second Amendment,
Right.
because that's the hypothetical I have about the constitutional carry states
Right.
in this notion of forced reciprocity or mandatory reciprocity. What's your answer to the hypothetical about the person who comes in from a constitutional carry state with a magazine over 10 rounds and/or an assault weapon?
So that comes down to it's not about what New Hampshire allows or doesn't allow. It's whether that comports with the Second Amendment period, whether
Right.
you can.
Okay, so
whether you can ban that. And I apologize, I'm not prepared to talk about those cases. I know there are cases percolating up to the U.S. Supreme Court on this very question, on the question of can assault weapons be effectively banned or,
So, obviously, McDonald, Heller, they all say there can be reasonable regulation, and this can be 50 different states, right? Obviously, 50 different regulations or types of regulations, as long as they don't impede the Second Amendment, which is the bellwether. But what if someone's from the state of Oklahoma and they think there's no such thing as an assault weapon, and that's fine there, and they drive into Massachusetts? Is that a problem?
So if the U.S. Supreme Court declares that that's both a dangerous and unusual weapon, and therefore it doesn't come under the protection of an arm, then Massachusetts can do that. It can be, in my view, it can be strictly to the Second Amendment, not less than, but strictly to. It doesn't have to go beyond. That would be my argument there. But the problem with this statute is that it temporarily disarms.
But what about the reciprocity?
I'm sorry?
What about the reciprocity from the person from the constitutional carry state? We don't have to extend the reciprocity to that level?
I haven't argued full faith and credit. I feel like that was persuasively handled in Commonwealth versus Harris. Again, I think it really just comes down to, is the U.S. Supreme Court, and I hope it eventually gets up there because I think that needs to be settled, whether that's a dangerous and unusual weapon. And this court's, of course, opinion in Kanjura is instructive on that. What kind of historical analog are you going to sort of see with that? And I can't think of one. I don't know where the Commonwealth will go. Would they go to canons? Maybe there was a canon ban and they can say, well, therefore, I just don't know. But I don't think the gravamen of it is reciprocity. It's, does Massachusetts comport, this particular law, does it comport
No,
with the Second Amendment?
I fully understand that the floor has to be
Right.
the Second Amendment, and if the Supreme Court says that there's no such thing as assault rifle, that's what we have to apply. But I'm trying to explore what happens to these folks who come in
Yeah.
and we don't know about fitness, we don't know about mental ability, we don't know about criminal records.
And on that, I defer to Attorney Levin's excellent argument that that's yet another reason to put a mens rea attached to this. That, usually ignorance of the law isn't an excuse, but there are those cases like Rahafe where, one's status, you do have to know your status. And I think.
But how does that affect the reciprocity issue if, go to your client, right? So your client comes over, he doesn't have the benefit, he's unlike Mr. Levin's client as far as the statute goes, but we don't know where he fits as far as suitability because he has a constitutional carry, permission to carry from New Hampshire.
Well,
We don't know if he's, right? So tell me how we handle that.
Sure. So with suitability, suitability actually proves that this is still a may issue regime. And if you look at Bruin.
But the Supreme Courts allow us to look into suitability.
Actually, Bruin says the
But
opposite.
not suitability, as far as mental illness and the like, right? And
Oh, I'm
whether-
sorry.
whether
We're
or not
going
they're-
back to Heller.
Whether or not they're felon, what categories, whether or not they're felon or mentally ill.
But those are objective standards, and we can get in an argument about whether that's dicta or not in Heller. But assuming that's operative law, that's still
Right.
an objective standard. And so what Bruin points out, I think it's page 13 of Bruin, it singles out regimes that have a quote, if you have a perceived lack of need, you don't get the license, or suitability, right? And so we still
I
have.
misspoke on suitability, but I'm more concerned about the categories we know that are non-controversial as far as criminal history and or mental illness. You agree with me that those, even under Bruin, are just qualifiers?
Those are disqualifiers.
Okay.
The problem is how you administer it, and we have to look at the historical tradition. We can't look at, the Supreme Court has told us again and again, we can't look at administrative convenience or the like. We have to keep to the historical tradition test. And the question is, can you, as a state, temporarily disarm the entire, literally the entire public outside of Massachusetts while that person tries to go through the hoops of a discretionary licensing regime?
But we do temporarily disarm everybody. But I take it, we're disarming out-of-staters much longer.
Much longer, and that makes it even more problematic, yes.
But are you suggesting that you can't temporarily disarm prohibited persons? Or to determine whether somebody's a prohibited person? Because that's the objective standard, I think, is what you're talking about, right?
If it were just on the prohibited, if it's just on the, so we're taking out suitability, I'm assuming in your hypothetical, okay. And so then the only guidance we have on that, temporarily disarming someone so you can find out whether he or she is a prohibited person, the only guidance we have on that is footnote 9 in Bruin. Bruin, that footnote is dicta because it doesn't have any historical analysis. So then the question is, how long can you make that person wait
So
for them
you
to
can
determine?
make them wait for some time, and we can argue about what the reasonableness of what that time is, but there is the possibility, consistent with the Second Amendment, to temporarily disarm somebody, as you say, in order to determine whether they are an objectively prohibited person.
Well, the problem is, again, footnote 9 is dicta, so there's no historical analysis. I don't know what the historical analog would be, because again, Rahimi only talks about after
So
the person
your
is found
position
dangerous.
is that Massachusetts and all states need to allow everybody to be armed until they determine that they are a prohibited person. So that even
Well,
the temporary disarmament of somebody would violate the Second Amendment, even if it's only for a reasonable period to determine if somebody's prohibited.
Well, Massachusetts can say, these are prohibited people, meaning you need not apply. You are banned. As long as those prohibited.
Well, they have.
Well, as long as the prohibited people categories are tailored to dangerousness, and there are some that are not.
Right,
So
but let's just stick with the hypothetical where they're just tailored to dangerousness. Then,
that might be constitutional. I just don't, the problem is that the footnote 9 just
But we-
doesn't have
but
any
we don't-
historical analysis
But we
on
don't
that,
know
so-
about your client. That's the problem.
right, but I think your position is that even temporarily determining, disarming somebody violates the Second Amendment.
Because, again, I
And
realize
even
there's
if it's
footnote
only
9.
for a
Yes.
reasonable period.
Yes.
Regardless of footnote 9. Your position, though, is that Second Amendment prohibits a state from temporarily disarming somebody, period,
I'm sorry.
unless they then determine that they're a prohibited person. While they're armed, they may or may not be prohibited, but we don't have a time at all, zero time, to determine.
Unless and until the person is actually found dangerous, or the Commonwealth, and again, I don't know what that is, but if the Commonwealth puts up a historical analog where there's,
That can't be right. How would the forum ever know? How would they ever know? If we just limit it to prohibited persons, and you're saying that every state could just enact a statute that says if you're a prohibited person, you can't carry. Who's walking into the state saying, hey, here, by the way, I'm a prohibited person?
I realize that is a compelling, administrative reason, and if we were in a means-end scrutiny world, that would probably be dispositive. But again, the body of Bruin says you got to do the
Reframe it.
historical tradition,
Could
and I just don't know what
reframe
that
this
is.
just a little bit, just to follow up on the way Justice Whalen phrased this? So we have the standing, put back in standing. Your client didn't request, I'm trying to understand what your client can actually challenge.
Yes.
So your client didn't request a license. This discretionary part of this, so he doesn't request a license, and I'm just trying to get a sense of how that adds to this. So the Commonwealth has a legitimate interest in at least screening for the bad guys, whether your guy is in that category or not. They don't know. Your person doesn't request the license, so they still have this legitimate concern. They don't know whether your person is in one of those categorical, so they have to have some time to make that determination. How does this case play out given that?
Well, as applied to Mr. Marquis, he is a law-abiding citizen, he's an adult, he's
We don't know
authorized.
that, but we don't know that based on, because he doesn't go for a license.
Well, we do know that because the Commonwealth would have
that's not- but
told
that's-
us that he's got this conviction or that. They've done that in Lode-Holt, they've done that in Johnson, they've not made that claim here. But even if the court sticks with Powell, and I think Powell is effectively overruled by Bruin because it was basically, this court decided that the right does not extend outside the home. But even if you find that they don't have standing, you still have to grapple with, just like they did in Rahimi, a facial challenge. The United States Supreme Court could have had a 2-page decision and said, well, Mr. Rahimi is obviously a violent, dangerous person, game over. But they instead grappled with the historical tradition. And there's just not a relevantly similar historical analog here.
If we were to posit a version of, just accept a version of 131F that complies with the Second Amendment, okay, just accept that it is. Can you then explain what remains, in your view, of the interstate travel argument, if anything?
So I'm just trying to make sure I understand the hypothetical. So the firearms competition restriction is effectively
Let's just
not.
all assume that, there's a 131F that satisfies the Second Amendment, that fully satisfies the Second Amendment. I'm trying to figure out whether the interstate travel right is coterminous with the Second Amendment, or does something survive of it beyond the challenge to the on Second Amendment grounds to 131F?
I see. So there are two issues I would see remaining. One is that there still is that fundamental right to carry, and so it's at least impacted by one's decision to travel, if that makes sense. But go
That
ahead.
seems to me the reciprocity, like if every state gets to regulate what's happening in its own state.
But it deters and burdens Mr. Marquis's travel. But aside from that, there's also the issue of the fact that in 129C, I believe it's 129CH, there's the equal protection problem of people carrying rifles and shotguns are exempted from a 10A prosecution, while if you've got a normal handgun, you're not exempted. I think that is huge, that one is
You think
burdened
it's
with
not rational? When there's no protected?
I don't think it's even rational, because if you have an unloaded handgun in your car, it's the same as an unloaded rifle, and yet one is subjected to a 10A 18-month mandatory minimum sentence and the other isn't at all. So I don't even think that survives a rational
The
basis.
fact that one's concealable doesn't do anything for you?
I'm sorry?
The fact that one's concealable?
One that's concealable but unloaded, and you're traveling in a car, I don't see that that's a distinction at all. And if you're given the same rights as a rifle shotgun carrying person, then you would have it enclosed, et cetera. So I think that still survives, because that's still an equal protection problem. And there's all the problems, I won't get into all of them now, but the wait time, the processing burdens, the fees that are involved, et cetera, those still survive as well.